to this honorable bench.
तुम लोग देख रहे हो कि तुम्हें ही बोलना है भाई थोड़ा सा नहीं सुनो भाई तुम बोल के देखो
Hello. Greetings to this honorable bench.
ये चालू करवाना भाई चालू तुम्हारा बहुत इवन तो
Lordship.
हाँ ज्ञान.
Your Lordship, if I may, does it sound good? Okay.
Hello.
तुम थोड़ा सा
Hello. हाँ है और छोटा कैमरा लगा है लॉजिस्टिक वाला. इन वॉइस आ रही था ना आएगी बिल्कुल सही लेकिन वो थोड़ा सा धुंधला दिख रही है नहीं. बाकी चल तो कि वॉइस बिल्कुल ओके आ रही है. अब लाली बार भी याद है मन में पहले भी देखिए नो प्रॉब्लम आएगा ना उन्हें वही चलेगा करेगा और लॉजिस्टिक वाला कैमरा ही चलेगा करेगा और यूएसबी के साथ आउट इनपुट में सही जाकर रहे जिनमें कैमरा लगा उनमें यानी आउट होना चाहिए. ठीक है एक बार. अरे वरुण इसको वो गेट बंद कर दो एक बार बेटा. एक गेट बंद कर दो वो वाला. दूसरा मंगाओ क्या लॉजिस्टिक वाला कैमरा तो हो गया साफ. अरे कैमरा साफ है हैं ठीक है. अब वॉइस आ रही धड़कन है बिल्कुल ओके है. उसमें घंटा बट ये एक्चुअल में इनको चाहिए इसमें चाहिए होता है कैमरा विथ माइक वही वर्क करेगा नहीं तो वर्क नहीं करेगा ये. हाँ
हेलो
हाँ तो वो उन्हीं एप्लीकेशन जी की है वो एप्लीकेशन दी ना वो थी एप्लीकेशन आपको किसकी व्हाट्सएप एप्लीकेशन उसकी थी गूगल मीट की. गूगल मीट में वो चलता है इसके ऊपर ये सिर्फ वेब कैम ले रहा है ऑडियो सिस्टम को अलग करने नहीं दे रहा कैमरे से. ठीक है मैं अभी है ना इसको 1 मिनट स्टैंड मंगा के लगा देता हूँ जो अपना स्टैंड वाला. ठीक है ठीक है वरुण एक बार बड़ा वाला स्टैंड लेके आता हूँ. स्टील का बड़ा वाला स्टैंड लिया
क्लियर ना आवाज.
Greetings to the bench. Greetings to the bench. Greetings to the bench.
45 plus rebuttals for 40.
45 plus.
45 plus.
Yeah, 45
क्या हो गया? सियारशीट? रूम नंबर 13.
उसको इस पे एडजस्ट करना दे यूं
ये एडजस्ट करना आपको.
इधर कर दे पूरा कर. हो गया भैया
ये देख लो.
वो यूएसबी साउंड नहीं होता था उसका उसको है ना सुन टेप से लगा दे टेप लगा दे
तो क्वालिटी अच्छी और जजेस आएंगे
सारा घुमा देंगे इधर भी इसको टर्न कर सकते हैं ना स्टैंड इसीलिए लगा
तो ऐसा नहीं है कि एक जजेस पे देख लो कर दो.
नहीं दो नहीं होगा बेटा दो माइक इस
ये आउटपुट नहीं आ रहे दोनों इन मानो भी।
हाँ सर। सर एक मिनट सर, मेरा ना कोई ऑनलाइन सर ये स्ट्रीमिंग है सर, मैं इसको सर स्ट्रीमिंग ऑन करूँगा सर, ये स्ट्रीमिंग चलानी है सर, प्रॉब्लम ये होगी, मैं चेक करवा देता हूँ, लेकिन सर मैं एक मिनट स्ट्रीमिंग पहले इधर इधर देख लिया मैं, मिल लिया
चलो बोलो सर के लिए।
अरे नेट नहीं चल रहा है, चेक करवाना है।
वो तो ब्लर यार, इन आउटपुट आना चाहिए नहीं यार ज्ञान में। कड़े साफ हो यार, देखो तो होते ना वो उठने तो को दिल्ली लाओ रे लाइव के चक्कर में
बंद कर, दरवाजा बंद करना। क्या फर्क पड़ा देख,
पड़ा ना
उलट
जो लाइट आएगी तो फर्क पड़ेगा। अरे ये चलो ना यार, चलता है, मैंने उस दिन किया था ना यार।
अरे वो है ना व्हाट्सएप एप्लीकेशन में चलता है ये,
इस पे चलो, इस पीसी पे चलो।
ऑनलाइन स्ट्रीमिंग नहीं चल रही है भाई, कोई चीज एप्लीकेशन सपोर्ट नहीं कर रही है उसको, जो कैमरे के अंदर लगा हुआ माइक होगा ना उसी से ही पकड़ेगा।
अच्छा
समझ गए?
ज्ञान में बोल
अब
दिया।
हाँ वॉइस जा रही है फर्स्ट क्लास, ये देख नहीं जाता है जो,
हाँ तो इस पे लगा हुआ ना आगे माइक इसका खुद का।
हाँ समझ गए,
इस पे माइक थोड़ी लगा हुआ
उसके अंदर माइक नहीं है।
तो वी कैमरा ये चालू कर दो, ऑडियो इसका ले लो काम में, दोनों निकाल दो ना डोंगल। हेलो हे 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 अब इसको सेट करना है आपको। वो यूएसबी डोंगल कहाँ है फिर वो वाला? देखो अब सेट है। अब ये कैमरा चेक करो आप पहले। चल रहा है ना?
कम पे हम बाहर रखना है, नहीं हम खड़े हो गए थे, हम खड़े हो गए। Perfect. This is such a nice video. Actually, एक photo split screen पे सेम स्क्रीन स्टोरी पे अच्छे से डाल दे पहले, और ग्रिड पे स्प्लिट करके और बीच में फाइनेंस वाला बीच में बड़े फाइनेंस
गूगल मीट पे चलता था वो,
गूगल मीट वगैरह सब पे वो चल जाएगा, लेकिन ये जो स्ट्रीमिंग करता है ना, इनबिल्ट माइक होना चाहिए कैमरे के अंदर, वो प्रॉब्लम आ रही है।
वो करो,
एक काम करो बेटा, एक कहने पर ना, या तो अपन इसको लैपटॉप को हटा के मार देते हैं, उससे लॉजिक क्या होगा क्या ना, बच्चे को चेक करो, या तो यहाँ पे कोई खड़ा रहे जो है ना, एक बार हल्का इधर भी दिखा दे और उधर भी दिखा दे,
तो वो उसको मोड़ के,
हाँ वो स्टैंड को मोड़ेगा हल्का सा, तो कैमरे को नहीं छेड़ना, नहीं कुछ उसको टेप से टेप लिया जल्दी कर टेप लिया हाथ में,
ये लो सर टेप ले घुमा।
एक बार देखो, एक बार सेट है या नहीं है।
बिल्कुल एग्जैक्ट ऐसे ही।
कि अपने को वो चाहिए
एक मिनट घुमाता है ना, 14 लाइव एक्चुअली घुमाए थोड़ा सा कैमरा घुमा, इन स्टैंड है, स्टैंड है
और हाँ वो तो मैं घुमा दूंगा, बोलो।
हां
स्क्रीन का
स्क्रीन का डिस्प्ले YouTube चला दो ना उसको लाइव पे,
नहीं उस पे नहीं चलाना, फिर उस पे तो अपने को दूसरी चीज चलानी है।
उसे तो लैपटॉप लगा दो एक वहां पे,
लैपटॉप लगा दूं
या पेन ड्राइव लगा दो, लैपटॉप लगा दो, एक लैपटॉप लगा दो,
पेन ड्राइव को थोड़ी सी
देखो देखो सेट कर दूं।
हां बिल्कुल सेट कर दो, ओके।
मैं तेरे को भेज दूंगा WhatsApp पे, उसमें फाइनल लिखा हुआ है वो वाला। तो देखो पीछे वाली स्क्रीन पे कैसे चालू होगा
वो बेटा एक ही लैपटॉप पे दो, एक लैपटॉप दे दो हमको, यहाँ पे यहाँ से वो कनेक्शन करेगा और दोनों पे चल जाएगा।
ये रहा HDMI कोड, ये रही।
हां
देख लो
और मैं सेट कर दूंगा तो लो हेलो।
ये बंद कर डाल दो बस, अब देख मैं कहता हूं थोड़ा सा ऊपर कर इसको,
ये बोल रहा टाइम
ऊपर करो
थोड़ा ऊपर
देखो।
बिल्कुल बेटा, ये देखो सही है ना। ओके,
प्रिंट करवा दे, मेरे पास वो है।
अपन चाहे तो इसको
नानी का लैपटॉप
ये पूरा क्लियर हो रहा है?
थोड़ा सा उल्टी कर तो वेट, थोड़ा सा ला बैक ले।
बोलो
हाँ बिल्कुल सही है, सब अच्छा दिख गया।
हमें
हल्को से घुमा दो, हल्को से घुमा दो।
मराठी ने?
वन वाला बच्चों नहीं दिख रहे, बस बाकी सब दिख गया।
लो देखो
हाँ बस ठीक है, हल्को से ऊपर, थोड़ा सा, थोड़ा सा ऊपर, हल्को से, थोड़ा सा, हाँ बस ओके। बेटा ये देखो सेटअप,
बस आपको ये गेट बंद करना पड़ेगा।
वो गेट बंद करोगे ना तो ये बच्चा आएगा, ये वाला दिख रहा है। अब जब आपको इसको दिखाना है, ठीक है ना, अब मोबाइल हाथ में रखते हुए ही ध्यान रखना है, ठीक है। ये सारे जजेस आ गए?
दिख तो थोड़ा सा ऊपर करना पड़ेगा।
थोड़ा और करो, और करो, बस।
अब हाँ ठीक है,
तो कोड ये बढ़ गया।
थोड़ा सा आप उधर करना, थोड़ा सा वापस वो स्टूडेंट्स की
बेटा
तरफ
एक
करना।
मिनट, एक काम करते हैं, इसको लैपटॉप को इधर घुमा देते हैं, ठीक है ना, ठीक है ना।
हाँ
हाँ तो
इस-
इसको
उधर रख दो, या तो हाँ पीछे से हम पीछे से बचाते हैं।
आपके सिग्नल का इशू आ रहा है इसका
वो आई विल
रहने दो स्क्रीन पे नहीं स्क्रीन बंद कर दो लाइव स्क्रीन स्टार्ट करो राउंड चालू करो
so excited that somebody lives next to me or something like that.
सुन कुछ मत कर ये अरे
हो गया
आ गया पीछे वाले भैया
भैया ये देखो ये तो है यार लॉक करेंगे चल
ये रहा देखो कोडे बंद रखो ये वाला
हैं
ये वाला कोडे तो बंद
हां पूरे बंद
total Thank you.
चलो
हां
अब लाइव चेक कर लो आपका
Because she's it's not very comfortable.
पीछे वाले पे
हेलो चेक हेलो चेक हेलो चेक चेक हेलो आ रही है एक ऐसे
What's the question?
वापस बोल दो
हेलो चेक
Your Lordship's permission, I shall approach the deck. May it please this honorable bench, I am Counsel T08, appearing on behalf of the appellants. May I address the bench collectively as your Lordships? Your Lordship, before we proceed, may I hand you out and hand you? Lordships, the present matter at hand centers on four main issues. With the Lordship's permission, I shall be representing Arakian Smash League for issue 1 to argue that BA has indeed contravened section 4 of the Act, and Greenspay for issue 3 to argue that it cannot be classified as a systematically significant digital enterprise. If your Lordships are conversant with the facts at hand, may I proceed with outlining my submissions? Much obliged, Your Lordships. Your Lordship, the present matter arises due to the dominating behavior of an entity that possesses not only a de jure but also de facto monopoly over the sport of badminton. It shall be our humble aim to show, Your Lordships, that their conduct in the garb of taking organizational decisions is nothing but a concerted effort to entrench their dominance over the sport of badminton and the athletes and viewers alike. Your Lordships, to argue that BA has contravened Section 4 of the Act, I shall lay before this honourable bench three primary arguments. First, the relevant product market, as defined by the Director General, to be the market for organization of professional badminton events and the market for services of professional badminton players, is correct. Second, BA has abused its dominant position in the primary market for the organization of badminton events to firstly deny market access to ASL in contravention of Section 4(2)(c) of the Act, and second, to strengthen its position as a procurer or a consumer in the secondary market for services of players to violate Section 4(2)(e) of the Act. And lastly, Your Lordships, it is our submission that the conduct of BA cannot be objectively justified as a legitimate sporting objective. May I proceed with my first argument, Your Lordships? Your Lordship's delineation of the relevant market is the pivotal inquiry before assessing the dominance of an enterprise. As per Section 2(r) of the Competition Act, the relevant market includes the relevant geographic market and the relevant product market. Since, Your Lordships, the facts do not indicate any sort of heterogeneity in competitive conditions across Arrakis, it is a humble submission that the geographic market must be the Republic of Arrakis. If I may proceed with the relevant product markets, Your Lordships. Your Lordships, the Director General has defined the primary product market as the market for organization of professional badminton events. It is a submission that this is the correct product market due to three primary reasons. First, there is significant product or service differentiation between badminton as a sport and other sporting events or other forms of entertainment in general. This product or service differentiation, Your Lordships, results in the absence of both demand side and supply side substitutability, which are considered to be the foremost factors while delineating a relevant product market. Your Lordships, as per Section 19 subclause 7 of the Act, the characteristics of the final product must be taken into consideration while delineating the relevant product market. At this juncture, Your Lordships, I shall draw your reference to the case of Dhanraj Pillai versus Hockey India. If you may access page 45 of our compendium, Your Lordships. Specifically, is the bench. Your Lordships, specifically at paragraph 10.6.1, they have laid down the principle of specificity of sport, which holds that every sport has unique characteristics that cannot be considered substitutable with any other sport or other forms of entertainment in general. Your Lordships, this product or service differentiation leads to the absence of demand side substitutability. Demand side substitutability refers to the cross elasticity between different products or services in the market. That is the extent to which the pardon, Your Lordships, am I not audible? May I proceed? Your Lordships, as I was, demand side substitutability refers to the cross elasticity between different products or services in the markets. That is the extent to which the consumers would consider the different products as substitutable with each other. In this regard, Your Lordships, defining the relevant consumer would be the relevant inquiry. As the decisional practice of the Competition Commission indicates, sporting markets are treated as complex, multi-sided markets, where there are several categories of consumers. From an end-use perspective, the ultimate consumer will be the viewer of the sports, whereas athletes too are consumers of the services of organizers of badminton events. Your Lordship, simply put, for either of these consumer groups, there is no substitutability between a badminton event or any other sporting event or any other form of entertainment in general. If your lordships are satisfied, may I proceed to my next?
As far as the viewer is concerned,
Right? Can we say that the badminton viewer will not view any other sport? You need to say that.
No, your lordships, I mean to say that there is no cross elasticity between different sports, in the sense that a consumer will not consider the sport of badminton as substitutable with the sport of cricket. Both market research and decisional practice indicate very limited cross elasticity between intersports, that is between different sports. And as for athletes as well, your lordships, who are another relevant consumer group, no professional badminton athlete will consider a badminton event as substitutable with any other professional sporting event. If I may.
I might be watching something, say a football match or something, say it gets interrupted, there's IPL going on side by side. I will necessarily, or I might switch from, say, watching a badminton match to a football match or cricket. So why do you say that there is no substitutability between it from your perspective?
Your lordship's substitutability does not refer to the practice of switching to another supplier or another product in the absence of one. It refers to substitutability between two products when both of them are present in the market. The consideration here would be, can a viewer switch from badminton to cricket without giving up on their consumer preferences? But the substitutability does not refer in the absence of badminton will a viewer watch cricket. That is not the test for demand substitutability.
Where are you getting that from?
This is the decisional practice of CCI, and as a general matter, the demand side substitutability.
Which cases?
Your lordships, the similar, the Dhanraj Pillai case, if your lordships may refer, specifically paragraphs 4.7.1.2, and several other cases, your lordships, which we have put forth in our compendium. 7.1.2. Pardon, your lordships, I do not have the page number. Your lordship, similarly, in other cases as well, the Surendra Singh Bhami versus BCCI case, or the Baseball Federation case, or the Chess Federation case, in all these cases, the Competition Commission has unequivocally held that there is limited to no cross elasticity from the consumer perspective.
But you are before the Supreme Court, right? So the findings of the CCI may not be, like, do you have anything else other than that?
Certainly, your lordship's finding, it is only indicative of the general trend in the sporting market, and market research as well indicates very limited cross elasticity between different products. In the BCCI case, they specifically conducted market research to show that there was no cross elasticity between cricketing as a sport and any other sport or other forms of entertainment in general. If that satisfies your lordships, may I proceed to supply side substitutability? Your lordships, the principle of specificity of sport also lays down that the governance of every sport is unique in itself and can only be carried out by the apex regulatory body under the international pyramid structure of the sports. The services provided by an entity like the Badminton Rackets in the present case, or let's say the BCCI or the Hockey India Federation, all of them are the apex regulatory bodies, and their services cannot be considered substitutable with any other services. If that satisfies your lordships, I shall proceed to the second market that needs to be defined. The lordships, the secondary
I'm not
market.
clear on that proposition at all. Demand side substitutability, supply side substitutability. Why are you saying that they are the only ones who are capable of making supplies? Because you're talking about different markets, right? Not just going to international competitions, but otherwise. Why are you saying that they are exclusive? Why are you saying that there is no substitutability to the association?
Your lordship's supply side substitutability refers to the practice of competing suppliers to switch to the services that other suppliers provide in the market without undertaking a significant switching cost. Compliance with regulatory barriers can also be a relevant factor while considering switching costs. Your lordships, any other entity cannot substitute the services of an apex regulatory body like BA or BCCI. That will require complete restructuring of the organizational structure of sports on an international level, which is an insurmountable switching cost. Your lordships, if that satisfies your answer, your lordships, as for the secondary market for services of players, in this market, athletes are considered the suppliers of their services, whereas the consumers are the organizers of badminton events. Your lordships, in this market as well, there is no demand side and supply side substitutability. Your lordships, no athlete of another sport can substitute the services with a professional badminton athlete. Similarly, no organizer of badminton event will consider the services of a professional badminton athlete as substitutable with a professional athlete of any other sport. Hence, there is no demand side or supply side substitutability. If that satisfies your lordships, may I proceed with my second argument?
This was us. You are saying that the market is supply of professional badminton players, right?
Is market for services of professional badminton athletes.
Where are you getting the word professional?
Your lordships, the Moot proposition.
Yeah. Can you point me to that, please?
Certainly, your lordships, if I may have a second to refer. But your lordships, you may refer to paragraph 12, your lordships, where it has been held that BA was abusing its dominant position in the market for organization of professional badminton events with the aim to strengthen its position as a procurer in the market for services of professional badminton players in Arrakis.
It doesn't say professional.
Professional. Certainly, your lordships, it does not say professional. But your lordships, as a general matter of fact, only professional athletes can represent the nation on an international level, and only a certain.
You have defined the market which does not include professional badminton players. It's a wider market which includes non-professional players as well.
Certainly, your lordships, that's still the impact that is being considered is only on professional badminton athletes who participate both in national represent qualifying camps and also in the Arakan Sporting League, your lordships. Regardless if your lordships wish to broaden the market, it is a humble submission that will have.
No, I'm not broadening the market. This is your submission, right? This is your. Your submissions to the DG which led to this conclusion of the market, where you have defined the market to be the broader market of professional as well as non-professional badminton players.
Your lordships, the DG has not defined these markets.
Who is defined?
This was our allegation as per the facts. Your lordships, the DG has only defined the primary market. The facts do not indicate what the DG has defined the secondary market as, and it is our submission before this honourable bench.
No. ASL filed its information in December 2023. It's a submission made by you.
Yes, your lordships.
So it's your submission that the market, the primary market, let's call it, market for organizing badminton professional events, whereas you are strengthening the power in the market for services of badminton players. Because there's a difference between professional and non-professional. Because non-professional players may not fall under the purview of the BA, right?
Certainly, your lordships, but if I may correct that submission, it is a humble submission since the restrictions relate only to professional badminton athletes who participate both in BA's events and the Arakan Sporting League. It is a submission that it may be, if your lordships will humbly restrict it to professional badminton players. May I proceed, your lordships? Your lordships, moving on to my second argument, it is a humble submission that BA is dominant in the primary market for organization of badminton events. Your lordships, under the scheme of the Competition Act, ability to influence the relevant consumers in its favor. Your lordships, on the ability to act independently of competitors, it is a submission that BA, by virtue of being the apex regulatory body, and as the facts indicate, by organizing almost 85% of all badminton events, either directly or indirectly in Arrakis, they are completely a dominant position in the primary market. If I may draw your lordship's reference to the Athletics Federation case, which you may find on page 327 of our compendium.
Once again,
327. Para 42 of the case, your lordships. In that case, your lordships, a dominant position was attributed on the apex regulator of athletics in India, despite the fact that it only organized 11 of the 300 athletic events in India, on virtue of three factors, which are in line with CCI's which is in line with decades of CCI's jurisprudence on the sporting sector. Lordships, the three factors were its position as an apex regulatory body under the international pyramid structure, its power to regulate and promote the sport, and lastly, its power to select and constitute the national team for national representative events. Lordships, since in the present case, BA fulfills all these criteria, it is a submission that they have the ability to act independently of its competitors. On the second aspect,
what about revenues?
Pardon, Lordship?
What about revenues? Is that a factor which should be taken into consideration?
Your Lordship, the facts do not indicate a specific revenue share for BA, but regardless, your Lordship, if an entity organizes 85% of all the badminton events, certain incidental commercial revenue generation will be inevitable, and they will have significant resources at their disposal.
Not necessarily. Not necessarily. If you were to look at the other events which take place, some of the private events generate a lot more revenues than all the local events put together would generate, while in terms of volume, the the numbers would be very different. If you look at cricketing as a sport, you have domestic events, club events, everything. And you look at the Premier Leagues which are run, they control all the revenues.
Like yourself, you control around 70% of revenue.
Certainly, Your Lordships, but to firstly address your point, while revenue, since revenue is not given in the proposition, and secondly, the revenue alone cannot indicate in the sporting sector is not a determinative factor of dominance. The decisional practice indicates that a dominant position can be attributed to an apex regulatory body if it possesses these significant regulatory strengths that allow it to act independently of its consumers and also influence the relevant consumers, that is the athletes and the viewers, in its favor. On the second,
But even you can do all of that with 70% of revenue share, market share,
to
the
address
organization of these events.
certain
The league is your league.
certain Your
Most of
Lordships,
so
revenue firstly cannot be the sole indicator of market power in this. Lordships, even if an entity gains 70% of the market power, BA has the power to control player selections in national teams, and as I shall contend, that gives them control of first in the primary market and as the secondary market itself, as they can virtually control in which event at the athletes participate.
Professional athletes.
Professional athletes, pardon me. If I may proceed.
That will not lead to a conclusion that they are dominant.
If I may also address the point on the ability to act independently of its consumers. Your Lordships, no viewer or athlete can exert significant competitive constraints on the conduct of the BA, as as the decisional practice of CCI and abroad indicates. Athletes are completely dependent on the services of the apex regulator for organizing national representative events constituting the national team. Hence, Your Lordships, they cannot constrain the conduct of BA in competitive. That satisfies the Lordships. The Lordships, to argue that BA has indeed abused its dominant position, it is our submission that BA has abused its dominant position in the primary market to first deny market access to ASL in contravention of Section 4(2)(c) of the Act. If I may draw Your Lordships' reference to the facts at hand, specifically paragraph 8. In paragraph 8, it is given, Your Lordships, that during the subsistence of BA and ASL's partnership, the January to February window every year was specifically reserved for ASL. However, in 2021, due to unfair demands of increase in revenue share, BA decided to break its partnership with the ASL and go off on a spree of anti-competitive behavior. Your Lordship, soon after breaking the partnership in 2022 and 2023, they have deliberately organized national selection camps at a time that conflicts with ASL's final matches, which for any league.
Deliberate use of the term deliberate seems to be a little uncalled for. Look, while you were having a contract with them, the calendars were synced. That's fine. You stopped having a contract with them, they are free to do the what do you expect? You don't have a contract with them and still they will sync their calendars with you per force because you are having an event, they will not have an event at that point of time. And then to impose deliberateness on that, that's a little extreme.
Certainly, Your Lordship, I agree with Your Lordship that abuse of dominance is an objective analysis, and there is no even a deliberate attempt shall not be a relevant consideration. However, Your Lordships, if you see the facts at hand, the national camps were organized with no precedent whatsoever during the most important part of ASL's league during its final matches. Secondly, this was despite the fact that the national representative camp for which the selection was taking place was almost 6 to 8 months in advance later in the year. In 2022, Your Lordships, the national camp was organized in February for an event that was in August to September. And in 2023, the national camp was organized in February once again for an event that was in November 2023.
there's no basis to say that just because they are organizing a national camp 6 months before the event, they are abusing the government. You yourself are saying that they are the expert. That's why they are dominant, and you can't replace them. Now they are the expert, and they are deciding when to hold these events for the country, because they sort of take care of the whole game as such for the.
Certainly, Your Lordships, if Since I'm running out of time, may I seek an extension? Few minutes. Yes.
2 minutes. Do you have any issue left after this?
Yes, issue 3 as well.
So I just go ahead with the issue 3.
Certainly, Asif, may I address your question on this point firstly? Firstly, your Lordship, it is submission that they have indirectly sanctioned players for the participation in ESL. They have given a choice to athletes to either participate in ESL or get disqualified from the national representative team and virtually play no badminton events for the rest of the year. This year, Lordships, as the facts indicate, has caused significant loss to ASL in terms of financial revenue and viewership. If I may quickly draw your Lordship.
Sorry, I don't get the sanction part at all from the facts.
The Lordships, essentially, they have, this is a form of indirect sanction.
So there, if you don't participate in the national camp, you can't participate, you can't be qualified. It's not a sanction. Sanction is saying that if you play for ASL, then you cannot participate or you can't play for that. That's a very different way of putting it.
Certainly,
If you don't participate, you expect to get qualified.
Yeah, I would cover it as a choice.
It's a choice. You have a choice between making money and representing the country.
For in competition or terms, your Lordships, choice would actually be a choice only when the counterparty can act upon it. In this case, your Lordships, indirect sanction, it is a form of indirect sanction. It is offers the player only two choices: to either play in ASL and get disqualified from the national team. Lordships, given the importance of national representative team, several athletes, including some of the key athletes in the rankings, chose to forego their participation, which caused significant viewership loss and revenue loss.
That's your problem.
That is a choice.
They exercise their choice.
They exercise their choice.
If I may quickly,
There are enough instances of athletes not taking up national contracts and being independent players who will go and play wherever they choose like playing. So that's a choice that the athlete exercises. So
Yeah, and the point is, look, I know you negotiated the January to March window. Could you not have chosen, I mean, couldn't you have spoken to BA and gotten another different window which works for you? Like, did you actually reach out to BA? Because that could have been another solution. Because I think one of the events you did only for a limited time period, it was equally successful. I think good for your coach.
Yes, you avoided that slot. So, and you
What
did it
about-
in December and you were as successful.
Lordships, to address all of your points directly, firstly, I shall draw reference to one precedent for Lordships. The baseball case, which you may access at page 72 in our compendium. In that case as well, your Lordships, the apex regulator of baseball deliberately organized its own league at a time. May I seek an extension?
you will be close on this argument within the following very short time and address your third
Certainly, Your Lordship.
issue for another minute or so. And close.
Certainly, Lordships. If I may just finish this.
Yes, quickly.
Lordships, in paragraph 30 of the case of baseball, the facts indicate that the apex regulator of baseball organized its own conflicting event at a time of complete overlap or deliberate conflict with another rival league. And furthermore, to mandate athletes' participation, they essentially offered them a choice to either participate in the rival league or participate in the league, which would select players for the national representative team. This was held by the CCI to be an unequivocal violation of Section 4(2)(c), as it in effect allows them to drive out the existing competitors from the market.
That case would also come to the sense, right?
Yes.
That is not the final order of that case that we are referring to has been appealed.
Certainly, Lordships.
Yes.
Yeah, and even there is sanctions, right? There is action going to be taken if you participated in the leagues, right? I mean, there is no sanction here. We are actually, I mean, the PA is actually giving a choice that, hey, listen, you want to participate in the private league, go ahead. I mean, it's fine. Whereas in the softball case, baseball case, sorry, there is sanctions were imposed. So, bit of a difference.
Lordships, abuse can take place directly or indirectly. Sanctions
No,
are
no,
also.
I'm talking about
You
the
use that case for,
Yeah, I think to the case of the point is.
Certainly, Lordships, the principle still applies that you can sanction abuse.
if it is deliberate, but deliberate is not proved, so this.
In paragraph 9, it is specifically given that after we rejected their unfair increase in demands of revenue, they deliberately organized, after the commencement of the ASL, the national camp. Soon, if I may refer yourself, Your Lordships, to paragraph 10. Soon after, we announced that it would hold a senior national camp in February 2022. Right after the deliberate business classes, Your Lordships, they organized a camp deliberately towards the most important part of the league, which is nothing but a deliberate, bad faith attempt to deny market access to this. If I may quickly address issue 3, Your
So
Lordships.
we give one minute for the one issue you are.
Certainly.
Yeah.
Lordship's third issue surrounds the disputed classification of GameSpay as a systematically significant digital enterprise. The standard for an SSD is similar to that of a gatekeeper under the European Union's Digital Markets Act. As the facts indicate, Your Lordship's GameSpay has not fulfilled the relevant quantitative criteria for classification as an SSD. To show that they also do not fulfill the relevant qualitative criteria, I shall refer to this one to three primary factors. Firstly, Lordship's GameSpay's slightly higher market share of 41% alone cannot be taken indicative of any form of market influence. Under the European Union Digital Markets Act as well, the market share raises only a rebuttable presumption of market influence. To rebut this presumption, Your Lordships, I shall come to my second prong, that is the presence of multi-homing. That is the ability of users to switch to rival aggregators with little to no cost. Your Lordships, fantasy sports as a market in itself is characterized in such a way that incentivizes users to operate across several platforms and strategize on the basis of rewards, discounts, price tools, etc. Hence, Your Lordships, there are no significant end user locking effects. And lastly, Your Lordships, to strengthen this point, the facts clearly mention that the market for fantasy sports is an emerging market in Arrakis. Your Lordship, is a well-settled principle that in an emerging market where competitive dynamics are still unfolding, no deterministic assessment of market position can be made. And lastly, Your Lordship, on my last prompt, in the Apple iPad OS case, in the European Union's DMA, certainly, Your Lordship, so that actually. Yes, sir.
Leadership, Lordship, good morning. At the core of this case is whether competition law should intervene in a market which is characterized as an emerging market. The emerging nature of the fantasy gaming market indicates that an intervention at this stage would cause significant harm to innovation in a growing market. Having this in mind, our submission to this court is simple. The presently growing and rapidly developing fantasy gaming market must be left to its own market devices, and a regulatory intervention against the appellants is unwarranted in the present facts. Your Lordship, continuing the submissions of the appellants, I have two primary submissions to make. Firstly, the exclusive licensing agreement entered into between the appellants is not void under Section 3 of that. And secondly, contrary to what the Respondent Commission contends, there is no violation of standstill obligations imposed under that. In addressing these two issues, I shall be making the following broad submissions. On the issue of whether the agreement is void under Section 3, it is our submission that the agreement does not cause anti-competitive effects in the relevant market. In alternative, we submit that the pro-competitive effects or efficiency gains resulting from the present agreement outweighs any such negative anti-competitive effects. On the other issue of alleged violation of standstill obligation, we submit that the conduct or the arrangement of the integration planning committee was for legitimate purposes such as integration planning in the pre-merger phase. I shall also seek to demonstrate that the parties were acting independently of each other and have not coordinated their business activities in a manner that would lead to violation of standstill obligation. If I may proceed from the first submission. Your Lordship, your Leadership, moving on to my submissions in the Section 3 issue, we do not dispute that the present agreement is a vertical agreement. It is also not disputed that the present agreement is an exclusive dealing agreement within the meaning of Section 3, subclause 4 of that. However, it must be noted that vertical agreements are not per se void. Rather, a plain reading of Section 3, subclause 4 indicates that a vertical agreement is void only if it causes an adverse anti-competitive effect in the relevant market. We submit that the present agreement does not cause such adverse anti-competitive effects. Before conducting an ethics analysis of the present agreement, we submit that the delineation of the relevant market by the CCA is correct. That is, the relevant market must be determined as the market for fantasy sporting games in our case, and the market must not be narrowed down to only badminton fantasy gaming apps as wrongly contended by the respondents.
Why so?
Certainly.
Why so?
This brings me to my next point, Your Lordship. I rely on both demand side and supply side substitution to establish that badminton fantasy sporting apps are indeed substitutable with fantasy gaming apps of other sports. With respect to demand side substitution, Section 2T of the Competition Act in essence lays down the principle of demand substitutability such that two products or service is considered to be substitutable with each other if the consumers regard them as substitutable or interchangeable. We submit that the consumers does indeed regard a badminton fantasy sporting apps as substitutable with the fantasy gaming app of another sport. This is because two products are considered to be substitutable from the point of view of the consumer if they share similar product characteristics or have a similar user experience. Fantasy sporting games does indeed satisfy this criteria, as all fantasy gaming apps are essentially paid for rewards by constituting a virtual team against the payment of a fees, without any significant difference in product characteristics or a user experience.
All sports, because you could also say that badminton is a separate game altogether. So
Just to acknowledge your concern, I acknowledge that there are certain learning costs involved in between switching between badminton fantasy sporting game and a fantasy sporting game to another sport. However, we submit that these learning costs are insubstantial to actually require
No,
presence of
I don't think that's the point. The point is, also essentially mentioned that from a viewer perspective, and let's assume that all viewers play fantasy sports. From a viewer perspective, a badminton event is not substitutable with the cricket event, right? That's the proposition. When it comes to from a viewership,
We should not dispute that position.
right? I don't think it's very strange that I'll be not watching a match but be playing fantasy sports, right?
To address your concern, Your Lordship, in the present facts, the fact scenario clearly shows that except for cricket, there is no other sporting league which is popular among in the present market. However, that clearly indicates that there is market for all fantasy sporting games. This should clearly imply that even though there's only popularity of cricket, the users in the present market use fantasy sporting games of other sporting leagues as well.
By that logic, they should also be watching other sporting events. Like if I'm playing a fantasy game, how do I play the game if I'm not watching the match, right?
Your Lordship, that precisely proves a point that even though there is no popularity except for cricket, and there is demand for fantasy sporting apps of other sporting leagues, it means that the users regard fantasy gaming apps of different sports as substitutable with each other. To address your concern, Your Lordship, a fantasy gaming app can still be played by various other factors to gain knowledge about the sport. It is not necessary that the fantasy gaming app should involve a viewership or a popularity of a particular sport.
Otherwise, who will play the fantasy, use that fantasy app?
Your Lordship, Ladyship, to address your concern, the present fact scenario clearly mentions that except for cricket, there is no other popular cricketing league. However, the fact scenario clearly mentions that there is substantial demand for fantasy sporting games of other sports. This implies only one thing, that users, even though watch only cricket, does use fantasy sporting games of other sports. This clearly means that there is a significant product differentiation between fantasy sporting games of different sports, due to the fact that all fantasy gaming app essentially involves users playing for rewards by constituting a virtual team against the payment of fees. Your Lordship, if Your Lordships are not concerned with if Your Lordships are concerned with demand side substitution, I can move on to supply side substitution. Certainly, Your Lordship. Moving on to supply side substitution, the test is whether producers can produce a particular product in the short run without incurring a significant cost, risk, or additional expenditure. As the fact record shows, same app developer continues to provide fantasy gaming sports of different sports within the same app. For instance, the present incumbent Tennis Sports was providing a fantasy gaming app of a cricketing league as well as a fantasy gaming app of a badminton league. This shows that the producers regard these fantasy gaming apps as substitutable from the supply point of view, as these producers are producing two different fantasy gaming apps within the same app. This shows that there is supply side substitution between badminton fantasy sporting games and fantasy sporting games of other sports. Therefore, for these following reasons, we submit that the relevant market to assess anti-competitive effects should be the broader market for fantasy sporting games and must not be narrowed down to only badminton fantasy sporting games as wrongly continued by the respondents. If I may move on to my submission of the AEEC issue. Your Lordship, having delineated the relevant market, I proceed to demonstrate that there is no adverse anti-competitive effects caused in the present market. A plain reading of section 3 subclause 4 along with the factors laid down in section 19 subclause 3 indicates that vertical agreements are subject to a rule of reason approach. What this approach means that there should be a balance between pro-competitive effects and negative anti-competitive effects to analyze whether a particular agreement causes impermissible restrictions in competition. We submit that the pro-competitive effects outweigh the negative anti-competitive effects. Firstly, it must be noted that DreamSpay, even though possessing a 41% market share, does not have a sufficient market power due to the very nature of the market, which is evolving and dynamic. Secondly, the agreement does not cause market foreclosure in the present market. And thirdly, and most importantly, the pro-competitive effects outweighs the negative anti-competitive effects. Coming to my first prompt, it is our submission that despite the fact that DreamSpay appellants hold a 41% market share in the fantasy sporting market, this cannot be indicative of market power. If I may refer the lordship to page C80 of the complaint in paragraph 15, it shows that 380. Your lordships, your dealerships, the decisional practice of competition regulators indicate that in an emerging market where the competitive dynamics are still unfolding, there cannot be any deterministic assessment of market power being made. Your lordships, similarly, the EU's regulatory framework indicates that in an emerging market or a market which is characterized as a growth sector, even though a market leader might possess a substantial market share, it cannot be indicative of market power, and said enterprise must not be subject to inappropriate regulations.
Let me pause you there for a second. Are you trying to establish whether they are dominant, or are you trying to establish whether there is an effect arising of the agreement? Because they are two different things.
Certainly, Your Worship, for analysis of Section 3 issue, it is required to firstly prove that the present appellant has market power in the present market to establish anti-competitive effect. It is our submission that the appellants do not possess market power to cause an appreciable adverse effect.
But is the crux of your argument on market power or on effects?
It also to briefly address that Greenfield does not even possess market power to cause an adverse
Okay, let's
effect.
assume they do. Okay, just for the purposes, let's get into the effects of the agreement to see why they say there is no effect.
Certainly, Your Worship. It is our submission that the present agreement does not cause market foreclosure. A market foreclosure is said to have been caused when the agreement A, it prevents existing competitors from increasing the market share, B, when it prevents the potential competitors from entering into the market, and C, whether it results in weakening of effective competition. It is our submission that there is no such market foreclosure caused in the present agreement. Your Lordship, as my co-counsel has already sought to submit, the market for fantasy sporting games is characterized by significantly low entry barriers with the presence of low switching costs to the users, and with the presence of multi-homing, with the effect of significant competition in the market. Seen in this light, the present agreement is unlikely to cause an anti-competitive effect due to the very significant and effective competition prevalent in the market. Your Lordship, moreover, the decisional practice of competition courts and tribunals have clearly established that exclusive bidding agreements do not always cause market foreclosure. For instance, in an English case of Bookmakers Afternoon, which is available in the yellow flag of a company, page para 468, sorry.
What was the duration of the agreement?
Certainly, Lordship. In the particular case, the market was kept.
Answer. What was the duration?
The duration in the present, the Bookmakers Afternoon or the present facts?
The case of.
Lordship, it was for 3 years.
3 years versus 8 years, huh?
Certainly, Lordship. It is our submission, which we dealt in my supplementary part of the submission, that this 8-year period is justified in light of the nature of the market, which is emerging market. Emerging market itself means that the market is characterized by non-cyclical uncertainty, which means that the market is dynamic and evolving. The present agreement, by providing an 8-year-long period for the exclusive agreement, provides a much-needed certainty in the market, therefore, as a response to volatility present in the market. Therefore, it is our submission that the 8-year period is really justified considering the nature of the market.
Nature of what market?
The nature of the fantasy sporting market.
Fantasy sporting market, right? Then how do you justify the cricket league not agreeing to an exclusive deal with the second player?
10 exclusive.
Yeah.
Your Lordship, it is not upon us to comment. It is not upon the appellants to comment upon the commercial decisions taken by the apex regulatory body for cricket in deciding not to actually have a non-generic version licensing agreement. However, we submit that the present agreement is really justified because of 2 reasons, which I'll be addressing the court on. There is no anti-competitive effect, and there is the pro-competitive effects outweighs the negative anti-competitive effects. Your Lordship, in the present English case, called the Bookmakers Afternoon, the market was characterized by 2 distributors holding exclusive licenses for 26 and 30 exclusive media rights for 26 and 30 racecourses respectively. In that particular fact, the English court found that the market competition was in fact competition to take these exclusive licenses and competition to sell these licenses. Resultingly, a grant of an exclusive license to one particular undertaking was not indicative of anti-competitive behavior, but rather it was an indicative of market participation. Similarly, in the present fact, all app developer continues to have licenses for a particular product. This makes exclusive licenses a market necessity or a commercial necessity for a party to even participate in the market. And also, it is true that it must be noted, Your Lordship, that exclusive licenses are usually sold on an exclusivity basis. Moreover, when the competition in the market was in fact competition to take these exclusive licenses, a grant of this license to one particular undertaking cannot be indicative of market power, but rather it is an indicative of participation in the market. If I proceed with my pro-competitive effects of the present agreement, it also comes to my third prong. In any alternative case, if this court were to recognize certain restrictive anti-competitive effects resulting from the present agreement, we submit that the pro-competitive effects or efficiency gains outweigh such negative anti-competitive effects. An agreement is said to cause pro-competitive effects or efficiency gains if it results in improvement in the production and distribution of the product, or it results in benefit to the consumer. We submit that there is both improvement in the distribution and of the product, and there is substantial benefit to the consumer. Various cases are recognized that exclusive licensing agreement can indeed lead to certain efficiency in the form of branding by providing a standardized and a uniform product. In the present case, certainly if it's a concern.
Yeah, do you have anything in the fact pattern which actually shows efficiency or consumer benefits? Anything in the facts?
It also there's nothing in the fact to show that there's
yeah, because I'll tell you why. You are basically saying that it's an emerging market, etc., to justify a lot of things, right? So then, I mean, if you're generally talking about market trends, etc., that shouldn't really apply, because you are limiting yourself that, okay, listen, it's an emerging market, so everything things do not need to apply strictly to me. But at the same time, you're saying, okay, the market trend is such that exclusive deals improve efficiencies, because at least again, the case law I have with me in front of me, which reported it's a 3-year agreement, like you said, compared to 8-year. And if you read 465 of that, this thing, you're saying that there was a commercial necessity to take exclusive licenses in order to enter the market against an incumbent. Like you're basically talking about an exclusive arrangement where someone's, if I read this correctly, is that you are basically trying to displace the dominant entity and therefore you have entered into an exclusive arrangement, which is not the case.
You are the incumbent.
Yeah,
so the present fact, the fact scenario in the particular case was indeed different. However, in para 468 of the same case, the court clearly indicates that exclusivity obligation can indeed provide a much needed differentiation of the product. This clearly leads to an efficiency gain in the form of GreenSpay being able to differentiate its ASL fantasy gaming product in an emerging market which lacks any significant product differentiation. And therefore, it is our submission by leading to a standardized and a uniform product, which even the consumers benefit from having a better quality. The present agreement.
But you know the facts. The facts don't. I mean, there's nothing in the fact pattern which says that. Right? That's the issue.
Certainly, there's nothing in the facts which show that there is an improvement in product quality. However, the allegation made by the respondents against us means that there is they allege that there is anti-competitive effects. Or we submit that even though this court were to recognize those anti-competitive effects, the pro-competitive effects outweighs any such negative anti-competitive.
Any point to substantiate that there are substantially, substantiate your efficiency.
You really should. There's nothing in the fact scenario. However, we submit that the present agreement is most likely to lead to a standardized and a uniform product, considering the very nature of the market and also the decisional practice of competition courts and tribunals, which clearly recognize certain efficiency gains resulting from this type of exclusive dealing agreements. For example, the para 468 of the case itself, which provides that.
So more at present, may in future, right?
Yes, certainly.
Why do you say that the generic exclusivity for the generic gaming is also going to help in improving the quality? You have the official branding in any case, you're not questioning that. The question really is, you're trying to say that I will have exclusivity even for generic gaming, and that will improve the quality at large. You have it anyway for your branding, professional branding and everything. That improves the quality out there, and let everybody do the generic one.
I acknowledge the concern, Your Lordship, but however, it is our submission that by making GreenSpay the sole and the exclusive licensee for the generic and the non-generic version of the ASL fantasy gaming product, it prevents the free rider problem. This essentially means that by making GreenSpay the sole, giving it the sole ability to produce ASL fantasy gaming product, it prevents other competitors from actually taking benefit of the innovation, the money spent on innovation and development of the ASL fantasy gaming product by actually producing a non-generic version of the fantasy sporting game, while GreenSpay invests such innovation.
No, there is a difference. There's a difference. No one is taking away your product. No one is taking away your game. That's a copyright issue. If someone takes away your innovations in your gaming, in your branded game that you're coming up with. Here is something who's coming up with a generic game. No one is taking that away. There are players who are playing out there. If I don't have Sanya Mirza in my team, then I'm not interested in having somebody with an X name who's not Sanya Mirza. I want Sanya Mirza in my team. What we are saying is that you're not going to, you can have the non-generic. Non-generic, you can improve quality. No one is taking away that innovation that you make in the non-generic gaming app. But in a generic gaming app, where no one is telling that it is ASL, no one is saying it is Sanyamisa, no one is associating anything with you. Why is that going to improve quality is something that I'm unable to understand. You can improve your quality in your branded app. How is it improving the quality by taking control of the generic app?
Your lordship, to address your concern by having these two, a generic and a non-generic version being produced in the same app with the same developer, it is most likely to cause a better quality product which the consumers can also benefit. And most importantly, it prevents the existing competitors from taking benefit of an app which they themselves have not developed and they themselves have not invested significant amount in developing a non-generic version of the game. The present facts in the appellants have invested significant amount in taking the licenses and developing a non-generic version of the ASL fantasy gaming product. By allowing other competitors to produce a generic version of the fantasy gaming product, it actually means that the other competitors are able to free ride on the innovation and development made by Dreamscape.
But that is happening across, right? Because I think for cricket you don't have the exclusive. I mean, you don't have the rights to the license names, etc. Right? You are then kind of free riding on whoever has the license, right? That's how the market functions.
Though, as you are interested yourself, that the market should evolve and grow, we're actually curtailing this ability for market to evolve and who people to be tested in these things.
Your lordship, it is our submission that there's enough commercial justification for the appellants to actually enter into this agreement. The question before this court is whether this commercial decision amounts to an anti-competitive behavior. Or we submit that there is no anti-competitive behavior because the pro-competitive effect clearly outweighs the negative anti-competitive effect. And most importantly, we are in no position to comment upon the other parties who have refused to actually license the generic version.
No. That was not my point. My point essentially was if you look at, I think, Annexure 1, which sets out the market share and the licenses held, right? So Dreamscape has the license for ASL, right? But Dreamscape does not have the license for APL. But Dreamscape does have the ability to give those generic fantasy applications. So isn't it just fair? And I'm assuming that's led to, I don't know, more people using fantasy applications, etc. So why wouldn't the same thing? I mean, I would think that there is a impact in the market because it kind of prevents people from putting in money to innovate, etc.
Your lordship, the facts now indicate that our competitor, that is Tenant Sport, indeed asked APL to actually provide the license for even generic version of the game. However, APL refused, and therefore it is our submission that that is their own commercial decisions. However, the present fact it clearly indicates that the present agreement in the badminton fantasy sporting game, which is an evolving and dynamic market, the present agreement is clearly justified in the market, which is characterized by significant volatility. Therefore, the present agreement by providing a much needed branding and a standardized quality product is necessary in the present market. If that addresses your lordship's concern, if I move on to my lordship, I see I'm running out of time. If I may granted 2 minutes to complete my submission on the substantial obligation.
Yes.
Your lordship, moving on to the on the substantial obligation issue, we submit that the conduct of the integration planning committee does not amount to violation of substantial obligations. This is mainly because the parties have continued to act independently of each other before the approval was granted by the Commission. 3 facts have been relied against us to make out a case of substantive conjunctive. The first being the information being shared in the Integration Planning Committee, as shown with the statement released on the 2nd of October 2024. The second being the discussion which the Integration Planning Committee has had on the joint bidding process, and the third being the participation of Dr. Schultz and Ms. Kiro itself. We submit that these facts by itself is no indicator of violation of substantive obligation. Firstly, it must be noted, Your Lordship, that it is a legitimate commercial expectation for the acquired company to maintain the business value of the target company in the pre-merger phase. A certain measure of sharing of information and integration planning might be considered to be legitimate in the period between the signing of the transaction and closing of the transaction after the approval. We submit that in the present fact, the sharing of information and discussions on joint bidding was indeed relevant to maintaining the economic and the business value of the target company in a rapidly and dynamically evolving emerging market. Therefore, moving on to my second point, Your Lordship, the Adani case has laid down the proceedings against Adani under Section 43 of the Competition Act. The case has laid down 3 factors which must be considered into account while analyzing violation of substantial obligation. The first being whether the conduct of the arrangement leads to potential competition distortions. The second being whether it results in weakening of effective competition. And the third being whether it amounts to interference with the ordinary course of business activities. On the point of the parties having discussions on the joint bidding process, the fact scenario clearly indicates that the discussions of the joint bidding process was inconclusive. the acquirer, that is the Dreamscape, got the bidding for the NFL deal under a competitive bidding process with the acquired company only giving a 2% lesser bid. This inconclusive decision and the parties continue to act independently and competitively in the bidding process clearly means that the parties have indeed acted in their own independent course of businesses and have not coordinated their business activities in a manner that will lead to violation of standstill obligations. And the second fact, and it is indeed acknowledged that a certain measure of safeguards in the form of clean game and confidentiality agreements is relevant to ensure compliance with standstill obligations. We submit that there were indeed such safeguards in the present litigation planning committee. The fact record shows that the participation of Dr. Schultz and Ms. Kiddo, who are the MDs and the CFOs of the respective company, was only in an advisory capacity. They did not participate in the meetings, nor did they actually vote in the meetings. These facts clearly shows that there were sufficient safeguards to ensure that there was compliance with standstill obligations. And more importantly, Your Lordships, the leadership, the decision of practice of the competition regulators clearly established that it is the effect of the conduct of the arrangement and not the intent of the parties which is relevant in analyzing whether there is violation of standstill obligation. The fact report showed that there was indeed no effect of potential competition disruptions as the parties continued to act independently of each other, as the bidding process shows where the acquired company got the bid under a competitive bidding process where the target company was indeed competing effectively. Therefore, for these following reasons, your sense of concern will be Your Leadership and Your Lordship, for these following reasons, we submit that there was no violation of standstill obligations, as the conduct of the parties was inherent and proportionate to certain legitimate objectives, such as maintaining
So
the
I
business.
think the issue is that the competition concern here is, like you said, that there is a difference of 2% bid, right? How do I establish that this 2% difference is not because of the discussions the two parties have had? How do you establish that? Because as far as I said, there was no clean game arrangement in the fact patterns mentioned here. Because if not for the transaction, they could have probably given a much different price, and maybe they could have, just to win that bid, competitively win that bid, they could have probably quoted 20% lesser. The fact that the bids are so close to each other actually shows that there is a collusion which thus was in fact a good competition. I mean, forget the fact that just standstill obligations, so it is not that relevant whether there is a distortion of the competition in the market or not. But even otherwise, there is potential distortion of the market, right? Because there is potentially collusive behavior here.
Your Lordship, to address the concern, the last paragraph of the Moot proposition clearly shows that the discussions in the joint bidding process was inconclusive. The parties had no.
Inconclusive, that's fine, but I mean, okay.
Your Lordship, this inconclusive decision means that the parties continue to act independently of each other and have not coordinated their business activities in a manner that would lead to violation of standstill obligation. For these following reasons, we submit that the penalty imposed on the appellants under Section 43A of the Competition Act for alleged violation of standstill obligation ought to be reversed. This brings me to my end of my submission, Your Lordship. Leadership. Thank you.
The council seeks permission to approach the dais. The council seeks permission to submit the compendium. Greetings to the honorable bench and may it please the court.
What is a code?
T20. T20.
What was yours?
T0.
Same.
Greetings to the honorable bench and may it please the court. We, the counsels on behalf of the respondents, shall be arguing in accordance with the issues framed by the court, wherein I shall be addressing issues 1 and 2 for a stipulated time of 22 minutes, along with my co-counsel who shall be addressing issues 3 and 4 for a stipulated time of 21 minutes, with 2 minutes being reserved for rebuttals. Before proceeding, the Council seeks permission to collectively address the bench as your honours. At the very outset, we posit that we shall, insofar as it is possible, be mirroring the appellant's arguments. Pertaining to issue 1, we submit that the actions of BA with regards to dealings with ASL did not result in an abuse of its dominant position under Section 4 of the Competition Act. With regards to this, we have two submissions. Firstly, that the very applicability of the Act is precluded because BA is not an enterprise within the meaning of Section 2, Clause H of the Competition Act. And even if this Honourable Court today were to interpret BA as being an enterprise, it does not fall foul of its obligations under Section 4 and has subsequently not abused its position of dominance. While we submit that BA is not an enterprise, we will be relying upon the very meaning of Section 2, Clause H, wherein BA is merely performing a regulatory function or a rather governance function of regulating badminton within the domain of Arrakis. And in order to refute that the actions of BA have led to an abuse of its dominant position, we will be breaking down the structure of the arguments on abuse of dominance in three parts. The first being that BA and ASL do not operate within the same relevant market. BA does not have a position of dominance within the given market. And thirdly, that BA has subsequently not abused its position of dominance because merely establishing BA as a dominant entity will not amount to abuse per se, and it is very important that an abuse be established at the very outset in order to hold BA liable within the meaning of Section 4 of the Act. With regards to the analysis on relevant market, we will be looking at both the product and the geographic market. And with regards to this, the Council would like to direct your Honour's attention to Section 2, Clause S and T of the Competition Act. Are your Honours with me? When we look at the very wordings of Section 2, Clause S and T, we see that there is a requirement of the competitive conditions being both homogeneous and interchangeable or substitutable. And when we look at this with the current factual matrix that we have, we see that the services that are being provided by BA and ASL fail to meet the test of demand side substitutability and supply side substitutability. Because BA is merely a regulatory body that is looking after the regulation and governance of badminton in Arrakis. Whereas ASL, on the other hand, is merely concerned with the organization of the league. So both of their functions are starkly different, and to hold both of them as operating within the same relevant market would indeed be faulty. When we look at BA's activities, it moreover has additional activities that it performs as well, which is the organization of national camps and the selection of players for international tournaments, which is its primary function. And when we look at the given market that has been defined as the market for organization of professional badminton events in Arrakis, holding BA as operating within this very constricted and narrow market would actually be erroneous and would end up ignoring its broader role as a regulating authority.
Are you saying that they are not functioning within this market?
Our submission with regards to this is that they are operating in a broader ambit and a broader regulatory function.
Which includes this market.
Which includes this
So
market.
they are functioning in this market.
Your Honours, they are functioning within this market, but this functioning is not to an extent that will hold it dominant and affect ASL's market presence in that regard. Moreover, if we also look at the geographic aspect of the relevant market, we see that BA is also competing with international entities. It is competing with international organizations for player placement, because under the pyramid structure, it is BA that is under this hierarchical system of selection, controlling which players from Arrakis will be participating in international tournaments, and it is competing with other countries for international player participation. So the homogeneity with respect to competitive conditions gets met over there. Wherein when we look at the actions of ASL, which is merely holding that particular Arakian Smash League, we see that owing to its location, target audience, and competitive landscape, its functioning is solely with respect to its functions in our case, which is also in line with the Surinder Singh Burmi versus BCCI case that is annexed on page 10 of the compendium. In this case, owing to this, it was held that BCCI merely functions within the domain of India because the competitive landscape, homogeneity, and competitive conditions is met only within that framework.
Okay, do you agree this is a case where the commission held them to be an enterprise? In the beginning, you said that you're not an enterprise.
In connection with that, the paragraph 6 of the memorandum proposition, it says, so they believe that your head believe that the deal would not be financially viable and fall within a couple of divisions. So what's your response to that?
Thank you for your questions. I shall be addressing them one by one. First, with regards to Justice Chauhan's observation, with regards to the BCCI case, in the BCCI case, the factual matrix was starkly different. And if we were to contrast the BCCI case with the current case at hand, we see that in the BCCI case, BCCI had authority over the grant of media rights and the sale of tickets, both of the functions which are not currently vested with BA. So it makes the very definition of enterprise fall flat when it's with regards to BA, which is solely operating within a regulatory domain. Moreover, with regards to your question,
So who grants the media rights for the national events that you conduct for choosing your players?
while the factual matrix or the Moot proposition does not
That
expressly.
is right. So you are organizing the event, you are controlling the event, you are the organizer, you are the natural corollary to that is all rights which flow from that event are yours. So
And that's why, at least some part of it, that's why you earn revenue of 6%. There's a revenue.
Well, that's why, yes, and that's why when you did the contract with ASL, you took a revenue of 6%. To say that that is not in your domain, I think seems a little stretched.
With regards to your question, we submit that BA's actions is primarily aimed at the organization of national camps and the selection of players for international tournaments. And while the factual matrix is silent on the role of BA in granting media rights, if I may direct your attention to para 7 of the Moot proposition, we see that ASL instead had media rights for the television channel and had an exclusive streaming deal with Hugo TV as well, which was a 10-year agreement. So we see that ASL is performing these functions and BA is just a representative of Arcus that is recognized by World Badminton as well. So its broader regulatory role is not really concerned with the grant of media rights. Moreover, in addressing Honorable Justice's question with regards to para 6.
Just one question here. So you are focusing on primary versus non-primary activities, right? Like you're saying primarily it's not in revenue generating activities or primarily not engaged in media rights. Is there a threshold which you can look at saying that okay, if out of 20 business activities, if I do 19 of them, which is regulatory, then I don't become an enterprise. Is there a threshold of how to justify? Because in my view, the moment you carry out even one revenue earning activity, business commercial activity, you become an enterprise. That would be my reading of 2H, correct?
I shall be addressing both of your questions because they are somewhat corollary. And with respect to this, if we look at para 6 of the Moot proposition, we see that BA indeed wanted to get a 6% revenue. But when we look at the very definition of enterprise, it does not specify economic activity. And when we are assessing whether an entity is under the definition of an enterprise under section 2 clause X, we look at the functional approach. And the functional approach does not look at mere sponsorship or the economic activity or the structure of the entity in itself. It looks at the overall functions that are being perpetuated by that very entity. And in this case, we submit that the overall broad regulatory function is the main domain within which BA is operating.
You are reading beyond 2H, so can you substantiate your argument with any citing any case or any decision?
Certainly, Your Honor. When we look at the Bar Council of India case or the Dutch Bar Association case, both of which are annexed in page 7 and 8 of the compendium, we see that it was held that both of them are performing broader regulatory functions. And while I do understand your concerns in holding BA as not being an enterprise, our main contention and our main submission today rests with the fact that regardless of BA being an enterprise or not, it has in fact not abused its position of dominance. And having established that in the very first place, the relevant market within which BA and ASL are operating is not same, its alleged dominance, as was alleged by the appellants, falls flat because if BA and ASL are not operating within the same relevant market in the first place, BA's presence of dominance in the very given market will not affect ASL's functioning at all. If we were to look at the relevant market in the form of a circle, if we see that ASL and BA are operating in different parts of the circle in itself, with BA being inside and ASL being out, the very fact that BA operates within the entirety of that circle will not even influence
Council, I
ASL.
think you're going against the argument that you put out first. I had asked you the question whether you also do the same thing. You said yes, which means the job that ASL does is a subset. It is like you are in the bigger circle. If I take your example, you're not working on two different parts of the circle. You are the bigger circle and ASL is a smaller circle. So it's not two different parts of the circle.
While we do understand this, our main submission is that even if we hold the relevant market to be somewhat interchangeable or somewhat interconnecting in that regard, BA's operations are not to stifle ASL's competition in the very first place.
Why don't you focus on that part?
Certainly. With respect to the abuse of dominance as has been alleged by the appellants, we see that first, the organization of national camps in the schedule that is very similar to ASL does not amount to an abuse. And secondly, the national camps as a mandatory criteria also is not abusive. We will be breaking it down to address each of them individually. Firstly, the organization of national camps in a very similar schedule is not abusive and is merely in line with the organization of the international tournaments in the first place. It is as and when that the international tournaments are organized that BA decides to hold its national camps, and these national camps are solely aimed at improving player fitness and player participation for fostering advocacy, participation,
You'll
and
have to answer to the question of it being reactive. The scheduling of the camp being reactive to you not being able to reach a deal with ASL. The question about timing of the camp, if it was independent, it happened all the time, historically at that point of time, you would have made a very good point. But your scheduling has been reactive. The moment your deal with ASL fell through, the moment they didn't give you 10% and you wanted an increase from 6 to 10%, you immediately scheduled it. It was pre-scheduled. You should remember ASL was pre-scheduled and yours was not pre-scheduled. So therefore, there is in the minds of the bench, there is a clear deliberation and action out here intended to effect that particular event which is happening. And it did effect. You can't deny that it didn't effect.
when we look at the chronology in which the Moot proposition has been framed, we understand that this will be a very valid concern. And this concern is in line with the way the proposition has been structured because it clearly delineates that after the renegotiation of 10% was being entered at, a seniors national camp was organized. But if we pay close attention to the very facts of the case, we see that the very fact that BA was a national regulatory body within Arikis, it had the authority to organize the national camps. And if we look at the way the national camps were organized, from paragraph 10 and paragraph 11 of the Moot proposition, we see that the first time around, the national camp was for a shorter duration, and that did not help Arrakis in the GC and EZC because they ended up losing in the semi-finals in both the tournaments. Versus in paragraph 11, when the duration was increased, we see that it dominated the BWC, winning 3 golds, 1 silver, and 2 bronze medals across the 5 events. This is very in line with the functioning of BA that has to look after the welfare of its players and participants alike. Moreover, with regards to the allegation posed by the appellants on this amounting to an exclusionary abuse, we submit that this is not exclusionary in any manner because when we look at the Harshita Chawla versus WhatsApp case that has been annexed to page 12 of the compendium, we see that there is no express coercion, and in fact, the players had a very valid choice to choose in participating for ASL or BA's events. And further, if we actually look at paragraph 10 of the Moot proposition, we see that some leading players instead even decided to forego their participation in the international tournaments to compete within ASL, which shows that ASL in fact also had a significant traction in the market, which is also further buttressed by the 70% revenue that ASL is earning in the very first place. Therefore, wrapping up our submissions, we wish to conclude by stating that the actions of BA have thus had a net positive effect that has benefited all the stakeholders and refutes any position on the abuse of its dominant position under Section 4 of the Act. Moving ahead with issue 2, we submit that the action of Greenspace and ASL to enter into an exclusive licensing agreement restricting competitors from providing generic versions of the game amounts to an infringement of Section 3, subsection 4 of the Competition Act. While the appellants have agreed that there is a vertical agreement in place, we shall be making 3 submissions with this agreement. Firstly, that the vertical agreement amounts to an exclusive dealing and a refusal to deal. Secondly, that the agreement perpetuates an appreciable adverse effect on competition within the meaning of Section 19, subsection 3 of the Act. And lastly, that this agreement is not even covered under the IP exemption under Section 3, subsection 5 of the Act. With regards to the vertical agreement, when we look at the very nature of the agreement in para 19 of the Moot proposition, we see that it is an 8-year exclusive licensing agreement that bars both generic and specialized versions. This amounts to an exclusive dealing agreement within the meaning of Section 3, Section 3, subsection 4, clause B of the Act. It is an exclusive dealing agreement that even falls foul of the Article 5 of the EU vertical block exemption regulations, which states that the permissible duration of non-compete clauses or such restrictive clauses should not be more than 5 years. But if we look at the present clause, it is for a period of 8 years. And this 8-year long duration of the agreement and its exclusive nature highlight its perniciously anti-competitive effects, making it liable to be struck down for failing to meet this criteria. Moreover, it amounts to a refusal to deal because if we look at the factual matrix of the present case, we see that Greenspace and ASL even refuse to negotiate with Tenet Sports when it approaches them. And the mere fact that it even refuses to negotiate with it clearly highlights its intent to even refuse to deal with it at the very first instance. Tenet Sports just approached them for a generic version infringement, and the very fact that they refuse to negotiate highlights their clear intent to foreclose Tenet Sports' market of operation. Moreover, when we look at the nature of the vertical agreement, our second submission is that it causes an appreciable adverse effect on competition within the meaning of Section 19, subsection 3 of the Act. Because first, ASL and Greenspace possess sufficient market power. If your honors may go to paragraph 21 of the Moot proposition, you will see that the market has been delineated as the market for sports fantasy applications. But since the market is for the market of sports fantasy applications, it is our contention that this market needs to be lowered down because the test of substitutability is not met within the given case. If your honors may look at the case of INRE Department of Sports annexed at page 23 and 24 of the compendium, it was held that sports such as table tennis, badminton, football, hockey, or cricket are not interstate substitutable for reasons including different consumer preferences. And even in the given case, badminton cannot be held to be akin of cricket or hockey or kabaddi for that matter. And thus the market needs to be narrowed down to the market for badminton sports fantasy applications.
The sports may not be interchangeable or exchangeable, but this is a fantasy gaming we are talking about. It's a different segment. I watch a lot of cricket. I don't do a single fantasy gaming. I know I would expect people who are doing fantasy gaming, you call it games of skill, but it may be a different element to it. They are interested in gaming all over.
Honorable Justice Kumar, I highly appreciate your keen observation in this regard. And with this, I would like to address what Justice Kundu had in fact mentioned when the appellants were arguing, wherein it was stated that there is a special type of skill that is required in operating the very fantasy game in itself. And this special skill is a prerequisite to be participating in the very given event. Moreover, when we look at the test of substitutability, we also see it from the consumer's perspective. And when we look at the consumer's perspective, they might have a skill that is akin to different sports. And with this, the mere holding up badminton as a as being substitutable with cricket or hockey would be erroneous.
When you use the term generic before that, you will understand why I'm saying that. If you use it which is not generic, which is branded and all of that, you have the names of the players, you are interested in the sport, you know all of that. When you have it generic in nature, then really it becomes substitutable because you're not basing yourself on great expertise about a player or a particular event. You're basing yourself on very different factors, which is where the substitutability question comes in. What my learned brother was indicating was where I have expertise in a particular field, I have knowledge in a particular field, I know how well Sania Mirza plays against left-handed badminton players. I use that in the branded space. In the generic space, that doesn't work that way. So it is whether it is a table tennis player winning or whether it's a badminton player winning or whether it's a cricket player winning. I really don't understand the difference.
Indeed, Your Honor, generic versions do not have the clear names, team names, or the brand name. But the generic games also have a format which is very similar to the very game in contention. And in this case, the game in contention is ASL, that is the Arabian Smash League, a badminton league. And in that regard, when we look at the sports fantasy application, it replicates the structure of ASL. So the very fact that it replicates the structure of ASL shows that consumers prefer it as a badminton sports league as opposed to a cricket sports league. And with respect to market power, if your honors, we look at Annexure 1 of the Moot proposition. The council seeks a 2-minute extension to quickly sum up their arguments.
2 minutes.
Certainly. If your honors, we look at Annexure 1, the 41% market share is with respect to the market for sports fantasy applications. And if we decide to narrow down the market to the market of badminton sports fantasy applications, this market share will also further increase significantly. And while we agree with the appellant's contention that market share cannot be a sole reliable factor for assessing market power, we see that in the present case, both of the parties have significant market share because it was highlighted that even ASL in the previous paragraphs 1 to 15, as per the report by Sabliness, ASL also had a 70% revenue. So both of these players have a dominant position in the market. And when we harmoniously look at the functions of ASL and Dreamspace, which are operating within a single entity of this fantasy sports application, we see that both of them entrench a dominant position and have sufficient market power to influence the very given market. Moreover, if we were to contrast the anti-competitive and pro-competitive effects to analyze whether an AAEC has been perpetuated in the given case, we see that the anti-competitive effects outweigh the pro-competitive effects. While the appellants allege that the pro-competitive effects existed in the given case, we seek to submit that this very agreement undermines consumer welfare and stifles innovation because consumers are bound by ASL and Dreamspace agreement and do not have the choice to operate with different licensors in this aspect. And competition law is a consumer-friendly law that seeks to uphold the interests of consumers as being paramount. And the very fact that this agreement stifles consumer protection is not pro-competitive. Wrapping up our submissions, this agreement is moreover not covered under an IP exemption because generic agreements in the very first place did not warrant an IP in the very first place. And moreover, even if the agreement also does not allow for this restrictive alternative because it is very unreasonable at the very outset and thus falls foul of Section 3, subsection 4 of the Competition Act. It was an honor being before this court and now...
One question before you pick, and I need a yes or a no answer. Your issue with the 8 year exclusivity period, right? Today, if I change it to 5 years, will you be okay with it and settle the case? Yes or no? No.
The agreement?
Okay, it's okay. Let's go. But you said no. Yeah. No, okay.
taking over issues 3 and 4 for 21 minutes. Much obliged, Your Honors.
Permission to approach the bar.
Greetings to this honorable bench. May it please the court. Your Honors, we are here before you today because the appellants seek to evade the regulatory scrutiny, despite there being ample evidence of their market influence and strong anti-competitive conduct. Your Honors, as introduced earlier, for the remainder of 22 minutes, I shall be addressing the third and the fourth issue, demonstrating how DreamSpace rightfully qualifies for an SSDE, that is Systematically Significant Digital Enterprise Designation, and how it has done a complete disregard to standstill obligations codified under Section 62A of the competition. Proceeding with the submission on the third broad issue, Your Honors, the ADCA, that is American Digital Competition Act, was enacted precisely to prevent the kind of conduct DreamSpace is engaging in. That is, leveraging its position, entrenched position that is to stifle up competition. Your Honors, as per the appellant's submission, they relied heavily on DreamSpace market power, that is 41%, and claimed that it is not significant enough to warrant an SSD designation. But Your Honors, if I may direct your attention to Annexure 1, annexed to the Moot proposition's last page. Are you honors with me?
Yes.
Your Honors, if you see the trend and as submitted by the appellants council themselves, then it is a very dynamic market. But if you see closely, all the other competitors in the market, except DreamSpace, have shown a declining trend, and their market share has reduced over the years. And it was only DreamSpace that had a significant increase in the market share, that was of 9%. Your Honor, it is thus our submission that the ability to have an entrenched position despite having multiple market adversaries where all the other competitors have done poorly and DreamSpace being the only one that has shown a growth trajectory, that is an upward growth trajectory, Your Honors. It is testament to the fact that DreamSpace has met the dominance threshold as required by the Act. Your Honors, the councils for
specific percentage threshold.
Your Honor, this is an gendered understanding from various case laws and even the how courts proceed. And apart from this, Your Honor, it is important to note that the 41% share is not seen in a static manner, as also advised by other case laws, and other countervailing factors is also accounted for. In the present situation, the fact that other competitors were doing poorly, and not just this, Your Honors, DreamSpace has also acquired one of the competitors, that is Edmund, and now the collective market share has gone up to a staggering 50%, which is basically half the market. Owing to these factors, it is our submission that DreamSpace qualifies for an SSA designation. Your Honor, the second opposing counsel, by concluding the submissions in this regard, submitted this, and I quote, regulatory intervention is unwarranted. Your Honors, in the case of FTC versus Kroger and Albertson, the courts went to the extent of stopping a merger, or that is by an largest player in the market of its competitor, because they feared that that might lead to an anti-competitive effect. In the present situation, the CCA is doing no such thing, and merely giving it an SSD label would ensure that such a conduct is prevented. The CCA has even approved that merger, but only seeks to add DreamSpace in the position of regulation to prevent further anti-competitive conduct. Your Honor, the
But if there are competitive concerns, why did the CCA not block the transaction? Or order divestitures or something of that, so some sort of remedies. Like the fact that they gave a clean chit to the merger and then designated it SSE, aren't they two contradictory positions?
Your Honor, to address your question, as per the chronology, the CCA first held that DreamSpace qualifies for an SSD designation, and then it gave a show cause to Dreamspace with that regard to present its case. While this was happening, in the later situation, Dreamspace and Edmund Games had a merger. And with this, it's also our intent and to establish that CCA does not try to over-regulate or stifle competition. The mere fact that we are not going to the broad extent or the extreme extent of stopping mergers or growth, but merely just giving regulatory checks is evidence to the fact that CCA's actions are proportionate and are looking at the broader angle of the market and not prejudiced to a particular party or entity. May I proceed to the next submission? Your Honours, the Council's submission regarding to multiple issues focused on this market share, but as evident, this market share is clearly seen to be very dominant, and by acquiring the competitor, there is only 3 other players in the market, which is evidence to the fact that Dreamspace has an entrance position. With this, the opposing counsel also raised arguments regarding the lock-in effect, and with respect to that, Your Honour, it is our submission that having an exclusive licensing agreement which allows only Dreamspace to use original player names is testament to the fact that this in turn would lead to an anti-competitive effect and because it creates a lock-in effect. Your Honour, this happens because having the original player names helps the users have a personal connection or attach their personal sentiment to the game itself because they are rooting for their favorite players. With respect to this authenticity creates user dependency because the players relate to the characters and it is not just a stimulation or an online application, but in fact something very real to them, which creates a lock-in effect, which Dreamspace is heavily relying on, and thus this creates a lock-in effect, Your Honor.
But just pause and pause it there. So let's look at Annexure 1. Okay. We have, okay, we know that cricket is the most popular, undoubtedly most popular sport, and badminton, etc. don't come close, right? I think both of us can agree on that. Then how do you justify Dreamspace having a 41% market share? Because I would assume it's because it has that exclusive license with ASL, but also the fact that they have presence in the generic market as well. So it's a combination of generic as well as the license one. So I don't think we can completely rule out the significance of generic category applications.
Honorable Justice Kundu, to answer your question in this regard, the entire badminton market is flourishing so much because of trends. As per the general social situation, trends play a very important role, and what is new and upcoming usually sees a very upward growth trajectory because that is the top thing in the market and the most up thing in the market. In that regard, since Dreamspace and since the badminton leagues were an emerging league, they garnered a lot of attention from the scene. With respect to the particular instance of generic version and the ASL licensing, it is our submission that it is very true that Dreamspace has a entrance position in both these regards. It already, like you very well pointed out, it already had a very strong entrance position, and with this additional licensing, it has further created a exclusionary environment for its application, and thus this further strengthens its position to the originally very strong generic version. With this additional exclusive licensing, it has further made its market position very strong. And this ASL licensing also creates a market which is less lucrative for new players to enter because the ASL creates a very specific market that only Dreamspace has an access to, and the other competitors which would even try to get in would not be able to do so because Dreamspace has a special access of having a very particular user base, or because the user base will connect to it because of the original contestants' names. Going to this is a submission. I sense a question concerning all that. Going to this, while the ADCA Act mandates the opposing counsel to negate not one but all 16 qualitative criteria, since this is an either or provision, it is a heavy burden of proof which the opposing counsel have not met. They have also failed to address the concern of self-preferencing which the CCA raised in the show cause notice, which was also backed by the DG's report, and all of this is annexed in the Moot proposition. Your Honor, self-preferencing relies to a situation where the own sister companies, etc., are given preference with compared to other players in the market. In the present situation, it is our submission that DreamSpay has used and given preference to its own sister companies' hosted contestants and thus also engaging in anti-competitive effects. As per Section 11 of the ADCA Act itself, self-preferencing could only be regulated if DreamSpay was an SSE. And thus, this further buttresses our point that had DreamSpay already been designated as an SSE, the CCA could prevent or penalize DreamSpay for such actions and thus create the market more and appreciate the market's more competitive spirit and make it more lucrative for other competitors as well as more friendly for the customer. Owing to which it is our humble submission that DreamSpay clearly qualifies for an SSE designation and thus should be given her. The Council now seeks permission to address issue 4. Thank you, Your Honours. With regards to issue 4, it is our submission that DreamSpay has given a complete disregard to its standstill obligations mandated under Section 6(2)(a) of the Competition Act. Your Honours, I would like to briefly point out the submissions made by the opposing counsel when they said that the Integration Planning Committee, that is IPC, is allowed by law and that was done so for the valuation of the target company. Your Honours, the fourth issue shall be demonstrated in a two-pronged manner. First, by identifying why the constituents of the meeting itself were violative of the Act, and in the second prong, while it is not necessary to show an appreciable adverse effect of competition, the Council will still do the same to further fortress the need for strict penalties in this regard. Starting with the first prong of my argument, Your Lordships, it is important to note that the opposing counsel has here created a red herring by pointing out that the IPC is allowed by law and making it a big part of their submission. But Your Honours, that was never the CCA's contention in the first place because as evident from para 29 of the Moot propositions last line, CCA gave the opposing counsels the permission to hold this IPC in the first place. There was never concerns regarding the holding of the IPC, but the CCA was worried as to what happened in the IPC. This concern has come because of two main situations. The first one being the members of the IPC, that is the advisors as they proposed, but that advisor's role was actually given to the CFO and MD of the respective companies. And the second concern pertains to what was discussed in the IPC. Your Honours, with regards to the first submission, that is the presence of CFO and MD. As per the Clean Teams guidelines provided by the compliance manual, it is very clear that for such a pre-approval merger discussion, only a specific set of people can be present in these meetings. These set of people are the ones who have no influence on strategic or financial planning of these companies.
Can you quote that language?
Certainly, Honours, it is present in the compendium. The Clean Teams. Copy takes 1 minute, so a few seconds. In the final page of a compendium, Your Honours, the para which starts after an invitation, including sharing of commercial sensitive information before such an approval is granted, is likely to be seen as an instance of gun jumping and may attract penalties under the Act. And this is also seen, Your Honours, this manual was also relied in the case of Google versus CCI, which also placed reliance on the Clean Teams provision and the need for the same. Your Honours, it is thus a submission that the Clean Teams provision is violated by having the presence of MD and CFO. CFO being the chief financial officer will have a heavy influence on the financial transactions of the company, and the managing director having hold with respect to strategic information. Owing to this, Your Honours, it is a submission that presence of both of these parties in itself was a violation of standstill obligation. With respect to this, In the second submission, Your Honor, the appellant counsel raised that the meetings had discussions pertaining to legitimate purpose and the reason for the same was given to be assessing the value of the target company. But Your Honors, it is a submission that the same should have been done before acquiring the company. As evident from the Moot proposition itself, the Greenspay acquired Edmund Games through a share purchase agreement which was executed on 1st June 2024. After executing a company, Greenspay would have no need to further assess the value of the company and hence the discussion's objective, which as proposed by the appellant counsel, itself raises doubts as to what happened in those meetings. With regards to this, Your Honors, it is also a submission that the presence of these two parties is not just a mere apprehension that might lead to an appreciable adverse effect on the competition, but in fact, as per the current situation, it indicates that it already has. Your Honors, if I may direct your attention to the Moot proposition itself, para 34 present on page 11, Your Honors. The second line of the para 34 states that the meetings, and this is recorded from the minutes of the meeting, which shows that it is a hard fact, involved discussions on the upcoming bids by Greenspay for NFL deals, including the discussion on whether Greenspay and Edmund Games should both bid separately for the NFL deal. Your Honors, this discussion can only happen after the consummation of the merger, but by involving and discussing on these things before the merger has been actually approved is a clear violation of the Act. Your Honor, it is also a submission that having these discussions had led to a violation of Section 3, subsection 3, that is bid rigging and collusion. Because, Your Honor, there has been between the two bids placed by the parties, the difference was merely of 2%. Such close bids are a clear indication of violation and
Why do you say 2% is very close? It can be even 0.5% and still vastly different.
Your Honor, that is a submission that the bids, just the mere discussions on the bid itself is a violation, as also seen in the beer cartel case or the case of Bearings cartel.
The discussion on bids were what? The discussion was not in the bid amounts. The discussion was whether we should bid separately or not. That was all the discussion that was, right? That's what the proposition says.
Since we are merging.
Exactly. Since we are merging, it's a commercial decision. Like, should we bid separately, but we are merging, we will close, so why can't we do one bid?
Isn't it logical to say that if I am going to be one company in final analysis, why should I have two bids going in? It makes no sense.
But eventually they did the right thing, submitting two separate bids.
Correct.
Your Honor, that is our submission that with respect to the meetings and the contents of the meeting, as per the Moot proposition second line, some of these meetings involve discussions on upcoming bids by Greenspay and FNFL. This indicates there could be other further discussion that actually dealt with the particulars of the value of the bids.
The proposition doesn't say so.
No, if there's some of these meetings involve this discussion. The meetings otherwise involve various other questions, not relating to the bids. But some of the meetings had a discussion around this issue. It does not indicate they discussed more about the bids or the commercials of the bids. That is nowhere which is put out here, nor is it intended in my understanding.
To answer Your Honorable Justice Kumar's concern with this regard, it is important to note that the difference of mere 2% was the basis of the inference being drawn. Since the bids were so close, it could be indicative of the fact of the.
If I was really going to be planning this out, why wouldn't I put a difference of 0.5%?
Your Honor, the same was done. It is our submission that the same was done to evade liability, and the two separate bids were placed to show that we were acting separately while already involving in the discussion. And to answer Honorable Justice Kundu's submission concern, you worried that this could be as a result of the merger itself, that since they were going to merge, they thought why not bid together. But
the discussion, why not bid together?
Also, tell me whether it was wrong for these senior people to be in the part of this IPC.
Your Honor, this is our first submission that the presence in itself is wrong, and as per the.
But it was not wrong according to the document you quoted. It clearly mentions that the senior people can be part of a clean team. Senior management can be part of a clean team. Please read the paragraph. If it is saying that you can be part of a clean team or IPC, and then they sit there, and there's a discussion that comes, and then eventually they decide not to submit a joint bid. How does the valuation work?
Your Honor, with respect to this, the claim teams allow uh, managerial position to be there, but only who hold CSI. In this particular situation, if those people also have the financial or the strategic power or the position to make the financial and strategic decisions, that violates the provisions of the claim team, Your Honor. And with respect to the discussions pertaining to the merger itself, as per the section 628, merely acting or consummating the transactions before the merger is approved. The merger was approved on 10th September, and these discussions were happening in the starting of August, Your Honor. And having this discussion during that period in itself is violative of section 628 and statute of limitations. Your Honor, it is also a submission. It is also a submission in this regard that as per the EU horizontal guidelines by
Where are you actually telling one thing? Just for the fact pattern here, we have the approval was on 10th September, right? And then on 2nd October, the press release took place, right? Which basically thanked Dr. King's patriots. So it's quite probable that the discussion happened after the CCA approval.
Your Honors, as per the para you quoted, the last line of the para thanks them for the discussions over the last 2 months.
Okay, okay.
So preceding the 2 months, the August discussions are the one in question. And as per the Act, the Act says something may is likely to, or the Council seeks 1 minute extension to the submissions in this regard. Your Honors, as per the provisions of this section itself, if we look at the very Act and take a literal interpretation, something that may lead or has already led to an AEC in itself is enough. We do not even have to go to the merits of whether the discussions were regarding to bid collusion or not. And
So which section talks about it?
Section 628 of the Competition Act. May I read it for the bench, Your Honor?
Yeah.
No combination shall come into effect until 150 days have passed from the day on which the notice has been given to the Commission, which in this case would be the September date. And under the subsection 2, or the Commission has passed orders under section 3, whichever is earlier. So the no combination shall come into effect. The coming into the effect part is the part we are relying on. And as per the combinations initial with the section 6.1, no person or enterprise shall enter into a combination which causes or is likely to cause an appreciable adverse effect on combination.
So 628.
Section 6 and section 6 to 8 on. To address the final same.
I want to see where it's AEC. Section 6 to A, right?
Yes.
Are you reading any other subsection other than 6 to A?
Section 6 also, Your Honor, because it's a part of the section. So no person or enterprise shall enter into a combination. Can I just take an extension to answer your question?
No, it's fine.
And Your Honor, to address the final claim of proportionality, a dominant party like Greenspan engaging in such practices and not penalizing them would set a bad precedent. With respect to the proportionality, Your Honor, the cases of gun jumping has given penalties as large as $121.4 million, and in the present situation, CCA has merely done a job of giving it a 1 million Solaris penalty, Your Honor, and owing to which we submit that considering all the factors and Greenspan's previous actions with respect to this violation of anti-competitive behavior, together the penalty is justifiable and should be adhered to. Your Honors, would you like me to recite the prayer? It has been an absolute honor to present before this court. Thank you for your time and indulgence, Your Honor.
Yes, 1 minute for rebuttals, 1 minute for
One minute.
preparatory time.
You want definitely.
Just 1
How
second.
long is the rebuttal?
I believe that we have 3 minutes.
3 minutes.
3 and 4.
But you guys don't need any extension for time after rebuttals.
Certainly.
3 minutes and 2 minutes stop. They raise the sign, you stop talking.
Certainly. I just have 20. I just have 1 minute.
Oh yeah.
Lordships to quickly address the respondents' allegations on the 4 issues. For the first issue, your Lordships, they have repeatedly mentioned that DA is a regulatory body and it is performing a regulatory function. By saying that regulatory functions are not under the purview of Section 2H of the Act, or in effect are not undertakings as per the European Union law, your Lordships, they are denying decades of jurisprudence to establish that every sporting regulator is involved in incidental economic activities and are completely subject to the purview of competition law. And to quickly analyze the impact of denial of market access, your Lordships, the facts indicate in 2022, right after the business disagreements, they first organized the ASL towards the end part of the league. Since not all players could forego their participation in that year, next year they organized it in January to completely from the outset ensure that no badminton player would effectively participate in ASL and its viewership would go down. This is corroborated by the facts itself, your Lordships, which shows that in 2022 and 2023, they hosted the lowest, they had lowest television rating since their inception and had the lowest viewed round of ASL since its inception. Your Lordships, this was a significant financial loss and is an unequivocal violation of Section 42C. Furthermore, they have not addressed the allegation of leveraging. Your Lordships, in the secondary market, by virtually controlling player participation in such a way where the athletes are actually the suppliers, they are in effect acting who the suppliers provide their services to, which allows them to act as monopolistic buyers. This, your Lordships, is a complete violation of Section 42E of the Act. As for issue 2, your Lordships, they have defined that there are substantial learning costs between playing for the fantasy sport game of one professional league and another professional league. Your Lordships, while there are learning costs, it is our submission that they are not substantial. The fantasy games, especially the generic versions, are only provide for a very limited understanding of the sport, which does not take a long time to understand. It does not take a long time to understand, your Lordships, how the sport of badminton or how the sport of cricket is played. Hence, your Lordships, their submission that there is no substantial learning costs. To quickly address issue 3, your Lordships, they have said that because we are the exclusive licensor of the ASL Fantasy League, we should be designated as an SSD. Your Lordships, under the EU Digital Markets Act and SSD, what the relevant market is not a determinative criteria. It is a completely irrelevant consideration. Your Lordships, the market must be considered on a whole, and it must be seen whether Teams Play has an impact on the market or not. Your Lordships, as my co-counsel established, exclusive licensing, especially in the sporting sector, is a commercial reality. Mainly because they have one exclusive licensing with a very small private league, does not mean that they have the whole market has a tendency to tip in their favor. Your Lordships, hence there is no viable classification as an SSD. And lastly, your Lordships, to address issue 4 as quickly as possible, your Lordships, they have said that it was our intent to have these members.
Responding to the rebuttals made by the appellants, with regards to issue 1, the regulatory functions, when we look at the regulatory function that is being perpetuated by DA, we see that it can indeed be granted an exemption, and that in fact was only a starting contention in this given case, and we look at how the primary contention on abuse of dominance was not met. In fact, if we look at the England and Wales case of billiards and snookers, there have also been instances wherein various sports have also been granted an exemption. Moreover, the second point with regards to the foregoing of participation, we see that ASL could have very well opted for an alternative scheduling, as it did in the 2024 season, which, when evidenced from the facts, was in fact even more successful than its 2019 and 2020 season, which shows that ASL was simply adamant in not organizing its event in an alternative schedule. Moreover, the point on leveraging a dominant position was not relevant to the given analysis because the very given market for services of badminton players was not met because the test of substitutability was not met in this case. The market for services of badminton players is a market that only BA had the authority to operate in, being the regulator and the authority for organizing the national camps, which ASL did not have in the very first place because ASL merely organized its sporting league. Moreover, addressing the concerns with regards to issue 2, it is not merely learning that has been relied upon for the generic versions, and we have also given due regard to the consumer preferences and how consumer preferences with regards to different sports cannot be held to be substitutable. With regards to issue 3, we have contended that ASL in fact creates a lag-in effect, which is only one of the criteria. Thank you. It was an honor arguing before this court.
Thank you. Thank you.
Pleasure arguing. Thank you.
Good job, guys. Thank you.
Really appreciate the efforts you have put at this. Complicated questions, just complicated facts, but you addressed it very, in a scholastic way. Thank you so much.
Your Honor, we were hoping that after you fill in the full sheet, you would give us some feedback.
Depending upon time.
The toughest of us is to run.
Yeah. But we will continue.
First, we will
This mic system को off कर दो आप. So how do you know the codes for it?
08.
Okay, this 20 is